Martin Pebo. Lawyer Martin Pebo, thank you so much for your time this evening. It's great to have you. Now, the big question is, should the president have been given the privilege of watching this video ahead of the publicized viewing by the public?
Well, Alfred, this is a very tough question. I should say that, for this one, everybody has an opinion. But to be candid, it would appear that for strategic reasons, he had to, being the number one gentleman, and also for the reason that his name was mentioned, to be fair to him.
Well, yes. It's been by convention, if you'd say, and that's over the period, all the investigations he's done, the presidents at the time have had to watch it before it comes into the public. But it's the action after he watched it that, many have raised questions about. I mean, how has the decision to have the CID invite and investigate Nyantakyi fed into, creating a basis for public opinion?
Well, it's become collateral damage. Yes, invariably, to the extent that the president asks for the investigations to be done. By law, once you say police should conduct investigations, most of the time it becomes public knowledge. So we can't quibble too much about it. It's collateral damage, yes. To appear that because the public is informed and everybody is concerned and trying to find out quickly what the matter is, it brings collateral damage that Nyantakyi's reputation would go down even before investigations are conducted.
I see, because this is Abdul Malik Kwekubako has actually been talking about a certain agreement they had with the presidency, which has been breached about this being put out before the public viewing. This borders on ethics, this decision by the presidents to go out against this breach. But does it bother on law, this decision to go out before the date, when there was an agreement not to do that?
Naturally, if there is a contract, as it says, the agreement, it would depend on the wording. You see, what I also do know for sure is that generally, even if an agreement binds you not to disclose certain matters, once there is the public interest for crime to be investigated and punished, a lot of the time there are exceptions. Yes, in law, you can sign an agreement, I won't disclose this to anybody, but if it turns out that what you're being asked to keep secret borders on crime, the public has an interest in having crime investigated and justice served.
See, now let's go into what the presidency talked about, defrauding by false pretense. I mean, English language, it is clear and understanding, but legally, I'm sure that it goes beyond what we understand in English. So what exactly is defrauding by false pretense in the law? Okay,
let's start with the easier way of understanding it, then we'll upgrade to a technical way of doing it. In normal English, it would just mean that Mr. A has lied to Mr. B in order for B to part with some property. So it could be money, it could be iPhone, any property. So A lies to B, and as a result of the lie, B parts with property, gives A some property as a result of the lie. Okay, so now go further. So let's say Alfred, let's say that your colleague Solis comes to you and represents to you that, okay, Alfred, I have a BMW in my, so let's say maybe 2017 model in my garage. It's going for, say, $70,000. I'm ready to give you a good discount. I would sell it to you at $35,000, and you quickly pay Solis $35,000. It turns out that Solis doesn't have a BMW in her garage. Okay, so in this case, she would have defrauded you by false pretense. See that she's lied that she has a car. It turns out that the car is non-existent.
So how about if Solis says, look, I was just bluffing? I mean, really, can she be set free, or can she escape any legal implications of that representation?
Yes, so if she can show that you didn't part with the money because of the car, that there were ways, there was information readily available to you to verify that she had no car, and yet you chose to part with the money, she would have a defense. So let's put it another way. So if the person makes a representation, and it's so clear on the face of it that the person is joking, or even if he doesn't say he's joking. And when we say joking, he doesn't have to use the word joking, but from the context and everything, you can see that he didn't mean serious business. You can't use that as a representation. You can't use that as a statement of fact.
So in effect, what you're saying is that if Kwesinyanti, for example, says, look, I was just bluffing.
Exactly.
There would be little or probably nothing to do about this case. Is that what you're saying?
Yes, and especially where critically you cannot show that there was a causal link between the statement and any money being paid. If you have to establish, as I stated, A makes the representation to B. So Solace informs you, says, give me this money in consideration of a car. You see, so there has to be a statement asking you to part with money in return for something. So there has to be evidence that you parted with your money in anticipation of receiving what was promised. That link is very important. So the person can say, oh, Mr. X is in my pocket. I can ask him to do X, Y, Z. But you don't part with the money. You haven't, and also in the context, it wasn't a serious statement. You haven't.
I see. So we should just probably be hasting with caution and not run ahead of ourselves with what is happening now. That's what you're going to want, right? But
exactly.
You see, I mean, lots of people have raised questions about the modus operandi of analysis investigations, and that particular argument is coming up again in this regard. And so even in the case of Raphael Kumoji versus Asari,
exactly.
which I can refer to as precedents, the Supreme Court is beginning to develop a certain abhorrence towards adducing secret evidence or secret recording as evidence. Is it enough jurisprudence to refer to in a case like this?
Not yet. You see, okay, when you say enough, certainly it helps. It will illuminate this case, but we cannot use those decisions to say that, oh, they are sufficient to to analyze this case to the end. Because the first is that, you see, in the Kubaji decision, the Supreme Court says they would go case by case. So you say case by case approach, and also the trial judge would exercise a discretion as to whether to exclude or to admit the evidence. So with these two, it means that the Supreme Court, and true, even without the statements from the Supreme Court, if you compare these two decisions to what's happened elsewhere, you can see that there's still a lot more ground to cover. Okay, but it's also instructive to know that from the decisions, those decisions did not cover situations where somebody has seen a crime being committed. You see, if you think in your estimation that you've seen a crime being committed and you secretly film, once you see with your eyes that this is a crime and you didn't entrap the person, you didn't cause the person to do it, oh, that one, it would be admissible. So there's still a lot more ground to cover.
Well, I want to thank you very much. And it's just early days yet, as they say. I'm indeed very grateful for your time this evening. Lawyer Martin Peeble, a paralegal practitioner, joining us with his thoughts on this developing story, I must say.